Hi, and welcome to Should I Care Civil Procedure podcast. I'm your host, Alexandra Lahav, and our special guest today, we're very excited, is Professor David Noll of Rutgers Law School. And the question for Professor Noll today is, why should we care about preclusion? So Professor Noll, why should we care about preclusion?
Hi, everyone. It's great to be on the Why Should I Care podcast. Um, so preclusion, a lot of civil procedure, you're going to discover isn't really about procedure, but is about various ways that the legal system tries to keep you from entering court, various doors that we put up to the courthouse to keep you from coming in. And preclusion, you should care about it because preclusion is the biggest, strongest, most powerful door that the legal system can put up that will prevent you from accessing court. When we're talking about preclusion, we're saying, just to focus on the word, you are precluded from bringing a lawsuit. So it doesn't make a difference whether you have a good claim. It doesn't make a difference if you write a complaint which tells a gripping story of how you've been wronged and how you need the court's intervention to get a remedy. It doesn't make a difference if you can satisfy various technical doctrines like personal jurisdiction, or if you can write a complaint which alleges a plausible claim for relief. If you're precluded, you're precluded. You're not allowed into court. And so we're saying, all right, go away. We don't want to deal with you here. So the question that raises is, right, why would we do this? Why would the legal system say, regardless of the merits of your claim, we don't want to hear from you? And the basic reason is that preclusion is a been there, done that doctrine. It says that if you had an opportunity to litigate a lawsuit, or in a version of preclusion called collateral estoppel, if you had an opportunity to prove a particular issue, we don't want to do it again. Resources are scarce, time is scarce, litigation costs time and money, and is difficult for everybody involved. And so preclusion is a one bite at the apple doctrine. It says if you have previously brought a lawsuit, or if you've previously litigated an issue, that's it, right? Under certain conditions, we're going to say, we don't want to hear from you again. We're going to close that door to the courthouse. So the way I've been talking about it, you might think that this is, a very defendant-friendly doctrine. This is something that mainly serves to protect defendants from litigation. But as you get into your readings for the civil procedure class, you're going to realize that preclusion is one of the most powerful tools that plaintiffs have available to them in litigation. And the reason for that is that preclusion is what delivers finality. It's what delivers peace. And so as somebody asserting a claim, what you can offer, your bargaining leverage, your ability to make the defendant scared, all of that comes from preclusion. If you couldn't put on the table the ability to finally make a lawsuit go away, well, then the defendant is never going to want to settle with you. The defendant's going to fight to the death. What preclusion does is it gives the plaintiff leverage by offering the plaintiff the ability to give the defendant peace and to say, if you lose on the merits, or if you enter into a settlement of the case that I've brought, then I'm going to leave you alone. And you can be certain about that. There's going to be some finality to either the settlement or the court's decision, which is going to allow you to continue with whatever it is that you do when you're not handling lawsuits.
So I just want to talk about for a second the difference between settlements and judgments. So when I bring a lawsuit, right, as I understand it, one way that preclusion attaches is I get a final judgment, right? So say I go through and I have it's very rare, but I'll have my jury trial, and then maybe there's an appeal, and at the end of the day, there's a final judgment on my case, and that ends it, right? And we know that then I can't bring a case arising from that transaction or occurrence again.
Right.
But when I settle a case, I'm really making an agreement, right? A settlement is like a contract. And then I might end up going to court to enforce that contract if the other side doesn't comply, right? So let's say I say to you, I'll settle this lawsuit for $100, and then you come and say, "Where's my $100?" And I say, "Ha ha, I'm not paying." Then you could bring a second lawsuit saying she breached her contract with me, right?
Right.
So what's the relationship between when I settle and the lawsuit ends that way, and when I reach a final judgment and the lawsuit ends that way?
Okay. Well, I think what students should keep in mind is that judgments and settlements are two very different ways of concluding a litigation. A settlement prototypically is a private agreement, and a judgment. Sometimes people are confused about what we mean when we say judgment. A judgment is there's actually a sheet of paper that says judgment at the top, and it'll say something like, in Noll versus Lahav, judgment that Noll takes nothing, or judgment, right? The court's judgment is that Noll takes $1 million and attorney's fees and costs and whatever else that I've convinced the court to do.
Oh, you're up in your claim there, Noll.
Yeah, well, this is a $high podcast.
Exactly.
So when we talk about preclusion, preclusion is usually thought about as something that attaches to judgments, right? We're saying when you get all the way to the point where the court is entering a judgment, the doctrines that you're going to learn in the 1L class, res judicata and collateral estoppel, are things that attach to judgments. However, as usual, the boundary between what the court does and what the parties do through settlement is a little bit hazy. So one way of settling a case is to do just what we were talking about, where the parties enter into a settlement agreement, which is just a contract. And one of the things you agree to do in the settlement agreement is to dismiss a lawsuit. Then you just have a dismissal, right? It looks like somebody voluntarily withdrew their lawsuit. But then there's other kinds of settlement agreements which are presented to the court for the court's approval, things like consent decrees, there are statutes where government agencies file suit against parties, and the statutes that they operate under require them to present settlements to the court. Then you can have a settlement agreement which has to be presented to the court for approval, which gets incorporated into a judgment. So in that case, you have a judgment that the preclusion doctrines apply to. This is getting very in the weeds for 1L civil procedure students. I think the important thing to remember is that parties resolving a lawsuit, they have a choice about whether it's resolved contractually through a settlement agreement or through something that results in a court judgment. And when you do something that results in a court judgment, generally, just as a huge generalization, that's going to give you a greater degree of finality, because if it's worse as a legal matter to violate a court decree than it is to simply breach a contract. If you breach a contract, the other side's remedy is to sue you for breach of contract or pursue whatever remedies are laid out in the contract. If you breach a court decree, now you're talking about contempt. Now you're talking about sanctions and a lot of really, really nasty things that the court can do to you.
Right. And also, though, just to get back to the power of preclusion, one of the things that you're getting, right, is that when you come back into court the second time, you can't even, I like the door metaphor, you can't even get in the door, because the other side's going to say, yeah, you already had your bite at the apple. Right. And the court will look at it and say, oh, yeah, you did. Bye. And so nobody can look at whether it was wrong, what else happened. It's basically the door is closed to you. And so that's an incredibly powerful tool if you can do that, because you don't have to relitigate anything. You don't have to open up any cans of worms. It's over. Right.
Yeah, and this is one of the things that's hardest for students who are just starting out in law school to understand, because in this class, we spent so much time thinking about getting it right. Right? What do you have to show or do at various stages of a lawsuit in order to satisfy the burden that the rules put on you. And we talk a lot about whether those burdens are fair, about whether they help the law's goals of deterrence and compensation. And when you get to preclusion, it's like all of a sudden we just don't care. I always put this on my final exam, and get a couple people every year. I have people go through a lawsuit, and then there's some resolution, and then something happens that really changes your view of the facts, right? A great aunt appears from the woodwork who has crucial testimony that nobody considered during the lawsuit, and she has an affidavit, and she's willing to testify, and her testimony is going to completely change the outcome of the case. And maybe the new testimony shows that the court completely got it wrong. And you say, okay, so now that there's new evidence, can we have a new lawsuit? It seems like what we did before was wrong. And the answer, the answer is no, right? There's ways to get out of a judgment, but if you don't get out of a judgment, that judgment is right. It's a signal that we're done with you. We want to move on to other cases. We want to move on to different matters. We're not going to relitigate. We're not going to do over what happened in the first lawsuit.
And so gets to my next question, and you may have already covered it, but what do you struggle with this topic, and in terms of when they're trying to figure out?
So preclusion is tricky because it has some of the worst terminology in all of civil procedure. It's a class that's filled with weird, non-intuitive terminology. In most 1L classes, you learn two different kinds of preclusion, maybe more, res judicata and collateral estoppel. Now, depending on what jurisdiction you're in, there are at least two, and sometimes more, names for those two preclusion doctrines. When we talk about res judicata, we also talk about claim preclusion. They're generally understood to mean the same thing. When we talk about collateral estoppel, another term for that is issue preclusion. Then when you get into collateral estoppel or issue preclusion, there are many different varieties of issue preclusion, not all of which are accepted in all jurisdictions. So there's just a lot of things to keep straight. So this is definitely one of those areas of the class where you want to look at the table of contents of your casebook and just make an outline of what the different doctrinal categories are so that you can keep them straight in your head. Because there's all these different terms for the same basic concept that lawyers float around. And what's worse is that the terms have changed over the years. If you were going to law school back in the 1950s or 1960s, you might use res judicata to talk about what we now consider an issue of issue preclusion, right? You litigated a particular issue and you're not allowed to relitigate that. So it's very difficult terminology to keep straight. So you should try to keep the categories of doctrine clear. But just a couple further points. One is that whatever kind of preclusion we're dealing with, it's always a doctrine where you've had one shot, right? You've had a bite at the apple. And people get tripped up on this, but this is something that flows throughout the preclusion doctrines. Even if one lawsuit looks like another one, even if there's a lot of overlap, the preclusion doctrines don't kick in until you or somebody that you're in privity with, someone that you have a legal relationship with, has previously litigated a claim or an issue. So it's always, it's always a situation of lawsuit one happened, something happened in lawsuit one, and now somebody's trying to do something in lawsuit two that's inconsistent with what happened in lawsuit one. So always, before you think that somebody might be precluded, you always want to check to make sure that somebody had their shot, had their day in court. And if you don't have that, you're not really having a preclusion discussion. Maybe you can talk about whether factual findings should be followed by another court. Maybe you can talk about precedent. But it's a preclusion question when you've already litigated something and somebody's trying to litigate it again. because the other thing I would say is that preclusion sounds like something that only kicks in at the end of a lawsuit, right? You go through the whole litigation process and you get a judgment, or you get a settlement agreement, or you get a settlement agreement that's entered as a decree in court, and then the preclusion doctrines apply to it. But I think you'll find as you start reading the federal rules and thinking about the way that they work, that there are some ideas from preclusion doctrine that run throughout the structure of a lawsuit under the federal rules. So just one example is under Rule 13, if you as a defendant have a claim against the plaintiff, Rule 13 says if that claim arises out of the same transaction or occurrence as the claim that the plaintiff is bringing against you, that's the so-called mandatory counterclaim. You have to assert that in the lawsuit as a defendant. So in the class, right, we have a lot of fun thinking about what a transaction or occurrence is. It's sort of this neat philosophical problem. We talk. There's 55 different ways that you can think about it. Really, it's driving at the same idea as preclusion, right? Is this a thing that should be litigated together? Are these claims that that naturally belong together? And then you're going to see, I bet, a surprising similarity between the way that the rules treat transactions or occurrences, the things that the rules want you to litigate together, and the scope of preclusion doctrine. And right, both of these doctrines, right, both the way we structure a lawsuit and the preclusive effect of a judgment, are getting at just this very common sense idea that, right, we want to litigate everything that's related to what's bugging the parties in a lawsuit. And we want to give them a full and fair chance to do that. But then once we do that, bug off, right? We don't want to hear you, right? We don't want to hear from you again. You've had your chance to prove your claims. You've had your chance to use the justice system. There's other people waiting, the wings get lost. So as you're studying the materials, I think it'll be very helpful just to keep in mind that we're trying to put together a lawsuit that's the right scope. And then the preclusion doctrines are sort of the hammer or the follow-up to what's happening in the rules in terms of cutting off your ability to litigate stuff that the rules tell you should have brought in an initial lawsuit.
Yeah, I really like that. I mean, so I tell my students that that the North Star they think they have a preclusion problem is to ask, did this person have their day in court? And a lot of other things can flow
Yes.
from. That's one first point you made. But then the second point you made, I almost feel like I don't do enough in class and is really important for students to understand, which is the aspect of preclusion, which is we do, I teach it at the end of the class. And I think a lot of professors teach it at the end because it's about learned all about how a lawsuit proceeds and then you learn how it ends. But in some, it's really about the beginning because the second court that's looking at the situation has to say, wait a minute, did these guys already do this? One shot, right? And then we see why these doctrines like Rule 13, why does it matter that they have to bring their claim or use it or lose it, right? Why does it matter? And the reason it matters is because if they're your client and they're gonna try to bring that claim later, they won't be able to. They're gonna be, it's a rule-based form of preclusion, right?
Exactly.
Those are great things for students to remember, that finality is important beginning because you don't want to lose your claim that you could have had obviously at the end, because now it's over. So those are, I think, both really good like ways to approach it. And I love the suggestion of going through and just listing all your doctrines and defining them rigorously. So you don't find yourself mixing them up.
This is just an area where you have to keep your head straight.
And Supreme full as it could be, because of your point about sometimes res do generally to refer to everything. And so it's important for students to be aware that that they should listen to whatever their professor, how the professor is defining it. And on the exam, that's who's grading it, not Justice Ginsburg. So you want to make sure that you're using whatever terminology your professor uses. So this has been great.
Right.
Thank you so much. Do you have any last words before we
Pleasure.
close? Can you,
I
I hope,
suppose just to,
oh yeah, sorry.
I mean, preclusion, it's a great topic. I mean, what it emphasizes is you should always be thinking about the end game, right? What's going to come out of a lawsuit, right? We focus so much on what's happening in a case, but when you get out into practice, clients aren't coming to you because they care what a summary judgment motion is or what the scope of a protective order is. They come to you because they want money, or because they want an injunction, or they want to get out of a lawsuit. And so always be asking, what's the end game? Always be asking, right, where is all this leading? And I think that'll help you make sense of a lot of what happens in civil procedure.
Yeah, it's very wise, and a good plug for remedies, which I think is also an important thing for everybody to be aware of.
Yes.
Not only
After
like,
you
did I
get through
get
the
a
first year.
final judgment, but where did I get at the end again? Because that's why you're there,
Right.
to achieve a goal. Well, thank you so
Yep.
much. I hope we can do this again. I really enjoyed it, and really appreciate your time, and I know the students do too.
My pleasure. Great being here.